Now we will look into the crucial aspect of amendment of Indian Constitution. Constitutions are the expressions of the will of the people. However, there are certain constitutions which are oldest in the world, like American Constitution, and there are very young constitutions also which are only few decades old. But nevertheless, the ideals, the societal values change from time to time. In certain societies, it progresses, it changes from generation to generation. But the question is, can the constitution remain the same? Can we have a constitution which is stable and not dynamic? So the answer is no. We cannot have a constitution which is stable. Why? Because stable law is no law at all. Stable law is a dead law. Dead law serves no purpose. So for that particular purpose, the constitution needs to be amended from time to time to ensure that it is in consonance with the ideals of the people, the aspirations of the people in that particular relevant age. So what may be relevant in the Indian Constitution in the year 1940s may not be relevant even today. So the times have changed. So to cope up with the requirements of the time and changing societal values, the Constitution itself has made certain provisions which speak about amending the Indian Constitution. Now, can you amend the Indian Constitution without any kind of safeguards? The answer is no. The Parliament has authority to amend the Constitution, but it does not have authority to amend the Constitution in whatsoever manner it likes. There is something called as basic structure, the basic ideals which are there in the Constitution, which cannot be taken away under the garb of amendment. Now we will look into the various aspects of constitutional amendment as mentioned in the Indian Constitution itself. Indian Constitution, remember, it is a living document. At the time of making of the Constitution by the Constituent Assembly, we have seen that there was a vibrant debates on various topics. Why? Because India is a diverse country. It does not have any kind of uniform culture. The cultural variations are there. The linguistic variations are there. The manner in which we dress, the manner in which we speak, the manner in which we eat, all these things vary from one part to the other, one place to the another. So to ensure that there is a constitution which is acceptable to all the nook and corners of India and which shall preserve the culture of the people and all, we should have something called as a living document, a breathing document, a living law which can be seen in day-to-day life. And I must say that Constitution is the only law which even a common person comes across. So, such is the relevancy of the constitutional law in the regular day-to-day functioning and regular lives of the people. So, it is a living document and it evolves through the amendments. So, how this living organism grows? It grows through various amendments. So, amendments are nothing but changes made to the Constitution. So, amendments can either delete certain portions of the Constitution, amendments can add certain portions to the Constitution, or the amendments can modify certain provisions to the Constitution. So, amendment can happen in three ways. That is either by adding something, or by deleting something, or by modification of some provision of law. So, changing socio-political needs. So, the socio-political needs of the people change from time to time. From decade to decade, we have seen that the needs of the people have changed. The domain of the state action has been reduced to a greater extent. Now, you have the free market forces going in the country. You have the various different political voices coming in the country. So, you need a constitution which is going to suit for all those socio-political changes. For instance, we have a constitution which does not take into consideration the present changes, or it remains static as it was made 200 years ago, for instance. So, in that particular situation, it becomes extremely difficult for the governing structure as well as the people to cope up with that old and outdated constitutions. So you will not get any kind of positive results by having outdated constitutions. So to ensure that the country is dynamic, you should have constitutional amendments made from time to time. Now, when we speak about the constitutional amendments happening from time to time, there are two examples which can be taken into consideration. That is, on one side, you can consider US Constitution, which is also known as the pocket constitution, the shortest constitution in the world. They hardly have 20 or so amendments. And it commenced in the year 1790s onwards. Then we have another stark example of Indian Constitution, which was adopted in the year 1949. Until now, it has crossed more than 100 amendments. So this clearly speaks the fact that India is a vibrant democracy. It is a culturally diverse country where the constitution has been amended from time to time to incorporate the ideals and aspirations of the people speaking through the lawmakers. So how it will happen, that we will see now. Why there is a need? That is the question. Why there is a need to have the amendments? The first and foremost thing is to update the outdated provisions. So remember, whenever a constitution has been prepared by Constituent Assembly of any country, they will take into consideration the existing circumstances. They will be taking into consideration the situations and the circumstances as existing on that particular day, and they will make a law which is going to suit that particular needs. They may have some sort of reasonable foresight, but they cannot have foresight of over 30, 40, 50 or 70 years for that matter. So just imagine the constitution makers of 1940s imagining about digital rights. So that was the time when we did not even have basic telephone in the country. So in such kind of situation, you cannot expect lawmakers to incorporate provisions pertaining to the digital rights. And in fact, that was recognized only a decade back. That is the rights pertaining, that is human rights pertaining to the digital world. That is right to internet also very recently. So we will see that to update the outdated provisions which are there in the constitution, constitutional amendments are necessary. And it is only through the constitutional amendments that we are going to update the outdated provisions in the constitution. Updation happens only through amendments. Updation only happens through the amendments. Then, to align with the socio-economic and political changes. The political scenario as existed in the year 1940s is not similar to which exists in this 2020s. It is totally different. Radical changes are there. You have multi-party democracy, you have media acting as the fourth pillar of democracy, you have changes, technological advances, campaigning all throughout the world. The world has become a global village. In that particular situation, how do you align your constitution which was made decades back? How do you ensure that your constitution remains relevant even after so many years? It happens only when you take into consideration the socio-economic and political changes. Only when you take into consideration the socio-economic and political changes, you can say that the constitution is up to date. Why? Because outdated law is no law at all. It serves no purpose, and it will in fact result in various kinds of irrelevancies or redundancies. Then, to uphold the fundamental rights. So, fundamental rights are the most dynamic part of the Indian Constitution, and you have plethora or number of rights being evolved by the judiciary from time to time through its judgments. So, recently you might have come across judgments where the Supreme Court has said that right to life includes right to sleep, right to life includes right to internet. So, when such kind of rights are being recognized by the courts from time to time within that particular provisions of Article 21, in the future it will become necessary for the Parliament to carry out the constitutional amendments to ensure that these fundamental rights are given formal shape within the Constitution. The same thing happened with the right to education. Right to education, which was once upon a time a directive principle of state policy, was recognized by the court as a part and parcel of Article 21, that is right to life. And later on, Parliament had introduced this right to education for the children between the ages of 6 to 14 as new Article 21A. So, how did it happen? It happened only through the constitutional amendment and to clarify the ambiguities in the constitutional provisions. So, there may be certain things which may not have been intended initially by the constitution makers, but as soon as the implementation started, the practical difficulties came into the picture. So, to resolve that particular practical difficulties, the Parliament has undertaken the task of amending the constitution from time to time. The best example is right to property. Right to property at the time of commencement of constitution was one of the fundamental right under Article 19(1)(f). So, what happened is the state, under the obligation to ensure equitable distribution of income or to ensure that the landless poor gets the land, had started imposing something called a ceiling law. When the ceiling law was made, then it was challenged on the ground that this land ceiling laws, that is the that is the upper limit for holding the land, will deprive the persons of the excess property which they have. So, it is in violation of fundamental right to property. Now, this has prompted the Parliament to amend the constitution again and again in the initial stages till the 44th amendment, when right to property was itself removed as a fundamental right. So, this was not intended at the time of making of the constitution, but in the long run it has resulted in such kind of irrelevancy or unwarranted circumstance. So, to avoid these kind of situations or difficult situations, practical difficulties, it is essential that the constitution needs to be amended from time to time. How and why? Here we will see. What are the different types of amendments? Amendments, generally speaking, they either add something to the constitution, or they delete something from the constitution, or they modify certain provisions of the constitution, or they try to substitute the existing provision with some other new provision. So, modification can happen in so many ways. However, there are different types of amendments or the procedure. Article 368 of the Constitution does not actually define what is an amendment, but it merely prescribes the procedure in which the Indian Constitution can be amended from time to time. First and the foremost, the most simple one is by simple majority. For example, any kind of constitutional amendment is there, it is moved in either house of the Parliament, and the simple majority of that particular house says yes to that particular amendment, then it becomes amending act and the constitution is amended. So, by simple majority, 50% and more, simple majority of the members voting, it is enough to carry out the constitutional amendments. So, sometimes they try to confuse this thing with the legislative power, that is the ordinary law making power. So, it is not like that, but nevertheless they have a simple majority whereby through simple majority they can amend the constitution. Very few provisions are there which can be amended through simple majority, but nevertheless simple majority is enough for them. Then you have by special majority. Now, when we are speaking about special majority, what happens is 2/3 of the members of that particular house should be present and voting. So, constitutional amendment should pass from both the houses of Parliament. So, in each house of the Parliament, certain provisions require that 2/3 of the members present and voting should say yes. And only when 2/3 of the members present and voting say yes, then it is deemed to have been passed by both the houses and it is given to the President for the assent. As soon as the President signs it, it becomes the law. So, therefore, there are certain provisions in the Constitution which can be amended. A majority of the provisions under the Indian Constitution can be amended through special majority, that is 2/3 of the members present and voting of the each house. Then you have by special majority along with the state ratification. So, there are certain provisions in Indian Constitution which speak about the federal relations between the center and the state. So, if there is a confusion, if there is an amendment which is touching upon that particular area, in those kind of crucial amendments, what will happen is it not only requires 2/3 majority, but it requires ratification by not less than 50% of the states. Ratification by not less than 50% of the states. So, not only 2/3 of the members from the respective houses should say yes, but also 50% of the states and more should say yes to that particular amendment. So, the GST was brought in this particular fashion. Remember, each type has different requirements based on its impact on federalism. So, whether it is a routine procedure, then it will happen through simple majority. Whether if it is somewhat a crucial provision, then it will happen through special majority. Or if the provision is very much crucial to the federal relations between union and state, in that particular situation, the special majority along with ratification of the states is mandatory. It all depends upon what kind of provision which we seek to amend, or what kind of provisions which the Parliament of India wants to amend in the Constitution. So, depending upon that particular provision, these kind of things, that is the procedure for amendment, varies from time to time. Then, procedure for amendment, as we have seen, Article 368 speaks. Now, here we will be dealing with the practical functioning, how the practical functioning happens. The first one is introduction of the bill. Constitution amendment can be initiated by introducing the bill in either house of the parliament. Either it can start from Lok Sabha or it can start from Rajya Sabha. And as soon as that bill is placed, constitutional amendment bill is placed before the house, it is extensively debated and then approved. So, bill we have seen that first reading, second reading, third reading happens, and in the third reading it passes that particular house. So, as soon as it passes through one house of the parliament, it is placed before another house of the parliament, where it goes through all these similar instances, and after getting passed by both the houses, it is placed before the president for presidential assent. As soon as the president gives the presidential assent, the amendment is said to have been passed and the amending bill becomes amending act, that is the law. President's assent is mandatory. Without the assent of the President of India, no bill can become constitutional amendment. So, just like in the case of any other ordinary bill where you require the President's assent, here also President's assent is mandatory. Without the assent of the President of India, the Constitutional Amendment Bill will never become Constitutional Amendment Act and no effect will be given to those kind of changes. And in some cases, ratification of half of the states. As I have mentioned earlier, we will find that when it comes to certain states or certain provisions which have crucial impact on the center-state relations, for instance, distribution of powers between center and state, the 7th schedule, then you have independence of judiciary, the jurisdiction of the Supreme Court of India. So, all these provisions etc. have a grave implication on the center-state relations. So, with respect to such kind of grave provisions of the Constitution, you have not only the special majority, but you also require ratification of not less than 50% of the states. In countries like US, it is next to impossible to amend the Constitution. Why? Because it happens only when the federal government as well as all the state governments say yes. But in India, that stipulation is not there. Only 50% or more states, if they say yes, that is enough for the provisions having bearing on the crucial center-state relations between center and state. Then, now we have to see certain landmark amendments. The Constitution of India came into force in the year 1950 and the first amendment was done in the very next year, that is 1951. In the year 1951, one of the crucial amendment is the First Amendment. What the First Amendment has done is, it has placed restrictions on freedom of speech. The initial constitution did not mention any kind of restrictions on freedom of speech and expression, which has resulted in the people misusing this kind of fundamental right and trying to make themselves immune from any kind of responsibility for the actions or crimes committed by them through speech and expression. So, to curb the misuse of the freedom of speech and expression, first constitutional amendment was passed in the very next year of enforcement of constitution, that is in the year 1951, and laying restrictions on freedom of speech and expression under Article 19, Clause 2. under Article 19 Clause 2. Then you have various series of amendments which has been done from time to time. Now, 42nd Constitutional Amendment 1976 happens to be the most controversial constitutional amendment. So, 42nd Constitutional Amendment of 1976 is also known as mini constitution. Why? Because 42nd Amendment tried to meddle with almost each and every crucial aspect of the Constitution of India. So, 42nd Constitutional Amendment 1976, it has added fundamental duties, it has added the word socialist and secular in the preamble, and it has increased the parliamentary term, and it has the prime ministerial elections immune from judicial scrutiny. So, such kind of radical reforms were made through the controversial 42nd Constitution Amendment of 1976, which is also popularly known as mini constitution. So, what they have done is 42nd Constitutional Amendment is a draconian amendment which tried to meddle with even the basic structure of the Indian Constitution. Then you have the 44th Constitutional Amendment of 1978. So, the 44th Constitutional Amendment of 1978 tried to rectify the defects which were there under the 42nd Amendment, and in certain cases it wanted 44th Constitutional Amendment had reversed everything which was done under the 42nd Constitutional Amendment of 1976. So, 42nd and 44th Constitutional Amendment are the most important constitutional amendments. Then you have 73rd and 74th Constitutional Amendments. 73rd and 74th Constitutional Amendments, which were passed in the year 1992, had created the three-tier government, that is the local government, which consists of the Panchayati Raj institutions and also the municipal councils and municipal corporations. So, for the local governance, 73rd and 74th Constitutional Amendment of 1992 are the most crucial ones. So, you had many amendments within, but during these periods of time, but these are the ones which stand out the most. So, 42nd is also known as the mini constitution, and whatever was being done under the 42nd Constitution, majority of the provisions were reversed through 44th Constitutional Amendment of 1978. So, due to the political tussle during the imposition of internal emergency, 42nd Constitutional Amendment was brought, and after the lifting of the emergency and the new government came into the power, central government came into the power, it has passed the 44th Constitutional Amendment of 1978 to undo what has been done under the 42nd Constitutional Amendment. Recent amendments. If we take into consideration the recent amendments, we will see that the crucial one is 101 Constitutional Amendment, 101 Constitutional Amendment of 2016, which has introduced the crucial aspect of goods and sales taxes, that is GST. GST was brought by way of 101st Constitutional Amendment of the year 2016. So, it was necessary to consolidate all the taxation laws in India and to have a uniform tax throughout the country. So, towards that particular step, they have established and they have passed goods and services tax by the parliament. So, for that particular purpose, to give a constitutional status to that particular authority, what they have done is they have passed 101 Constitutional Amendment in the year 2016. Then you have 103rd Constitutional Amendment of 2019, which has secured 10% reservation for economically weaker sections. So, economically weaker sections, or popularly known as EWS quota, was introduced by way of 103rd Constitutional Amendment in the year 2019. In the year 2019, they have passed 103rd Constitutional Amendment providing 10% of reservation for economically weaker sections who are not covered under the category of SCs, STs and OBCs. Then you have the most recent one, that is 104th Constitution Amendment in the year 2020, which has extended SC/ST reservation in the legislature. It has increased the SCs and STs reservation. The reservation was for initially 10 years and it was being extended from time to time. So, in the year 2020, these reservations were further extended for a period. That is, reservation of seats for SCs and STs in the state legislatures and the union parliament also, that was extended. The provisions for providing the reservations were extended by way of constitutional amendment in the year 2020, also known as 104th Constitutional Amendment of 2020. So remember, the amending process ensures that the Indian Constitution remains lively and dynamic while maintaining its core democracy values. So I told you earlier that you can amend the Constitution, but you cannot break and mend it to suit your own needs. So democracy depends upon the people. So for lively people or the people who are diverse, you require a diverse constitution which is relevant to that particular period of time. So in conclusion, I would like to say that amendment is essential for the very existence of the democracy which we live in. Thank you.